Justice Amy Coney Barrett, thank you so much for the time.
Thank you for having me, Brett.
You know, the title of this book, Listening to the Law, why did you write it?
I wrote it because I really love the court and I love the Constitution, and I wanted to invite people to experience the court and Constitution with me.
And was part of it demystifying the court or the process?
Yes. You know, I speak to a lot of school groups. I speak to young children, I speak to lawyers, non-lawyers, all kinds of people. And I get the same questions across groups. How does the court get its cases? How does the court decide cases? Do the justices get along? And I can't answer all of those questions one-on-one, but I can write a book so people can find the answers if they're interested.
Yeah, I've read it, and there is a lot of mystery and intrigue about what happens inside these walls. And the perception of that, like everything else in Washington, is that it comes from a partisan point of view, that there are somehow teams here, depending on which president nominated you for the position. But you write about things like the assigned seating in the court and what you wear when you go to the courtroom, and basically how the outside perception is not the inside reality.
That's right. You know, we don't wear red and blue, we all wear black, because judges are nonpartisan, and the idea is that we're all listening to the law, we're all trying to get it right. We're not playing for a team, we don't sit on specific sides of the bench, left and right. You know, we sit in order of seniority.
And when you listen to the perception about how it's done, what is your thought about that?
Well, there's a disconnect between what happens inside the court and what people think happens inside the court. I often ask new law clerks, what surprised you most when you started? And one of the most common answers is the difference between what's happening on the inside and what people think is happening on the inside.
So, for example, in fact, the focus is always on these divisive cases and decisions, but there are a number of unanimous decisions that the media doesn't cover every year. I mean, we have 42% in this past term, 2024, 45% in 2023, 47% in 2022. You write, one who follows the court casually might be under the impression that practically every case is decided with the appointees of a Republican president on one side and the appointees of a Democratic president on the other. While that breakdown sometimes occurs, presenting it as the norm grossly distorts the court's work.
That's absolutely right. You know, last year, I believe it was 6 cases, you know, roughly around 10% cases broke down by party of appointing president. That's a pretty small number given the overall number of cases that we're hearing.
That said, the current perception, like I said, is that the left is saying this court is protecting President Trump in his effort to consolidate power. You can see that really from the recent headlines. There's a lot of them about that. The overwhelming evidence that the Supreme Court is on Donald Trump's team. New York Times, the Supreme Court is backing Trump's power grab. NBC, in rare interviews, federal judges criticize Supreme Court's handling of Trump cases. They say you're helping to certify this move towards authoritarianism. How do you respond to that?
The court decides cases as they come. And one thing that I try to emphasize to students, and one thing I try to do in the book, is place the court in the context of history. We're not deciding cases just for today. And we're not deciding cases based on the president, as in the current occupant of the office. We're deciding cases about the presidency. So we're taking each case and we're looking at the question of presidential power as it comes. And the cases that we decide today are going to matter 4 presidencies from now, 6 presidencies from now, and so on. Each of these cases that we're getting, you know, well, I mean, some of them overlap, but many present different constitutional issues.
Mm-hmm. The right obviously looks at it completely differently, saying federal district judges around the country are overstepping. They're unelected, making sweeping decisions about a president's executive power. When you have to deal with those, it often comes in the emergency docket, which is something different that people don't fully get. Mm-hmm. Can you explain that?
Sure. So the emergency docket, these are not cases that come up on our regular October term merits docket. Those cases are the ones that I primarily focus on in the book. There are about 60 of them per year, and they proceed very slowly with briefs and oral argument and a lot of deliberation. These emergency motions come up when a case has not fully been decided and settled in the courts below, and they ask for the court's emergency intervention to enter a stay, usually, or sometimes to lift a stay, to maintain a particular status quo while the issue is being litigated in the courts below. So it's not a definitive resolution. It's what Justice Kavanaugh calls the interim during the interim.
There are a lot of them, though. This administration has filed almost 24.
There have been a lot.
And is that because you see more federal district judges stepping in and doing that?
I don't know. You know, the phenomenon of cases being brought on our emergency docket started a few administrations ago. There were some in the Obama administration. There were some in the Biden administration. And now we do have, it seems like we're on a trajectory to have more in the Trump administration. I don't know. I think it's a combination of, you know, increasing use over time, not just this administration, of executive orders. And I think that all the judges, district judges too, are just doing the best we can with a lot of litigation that's been filed.
Most times you're not saying, again, about the merits, you're saying about the process, and specifically what should or shouldn't happen at that time as the case is progressing through the system.
Exactly. It's just, what is the holding pattern going to be? What are we going to do for the interim while the case is litigated? It does not mean that we have reached any definitive resolution about the constitutional or statutory question in a case.
In June, ruling on one of those cases, Trump v. Casa on birthright citizenship, you wrote this: federal courts do not exercise general oversight of the executive branch. They resolve cases and controversies consistent with the authority Congress has given them. When a court concludes that the executive branch has acted unlawfully, the answer is not for the court to exceed its power to. Some of your colleagues, including Justice Ketanji Brown Jackson, said that reasoning was a, quote, existential threat to the rule of law. I mean, that obviously got a lot of attention, that whole back and forth. And your response to her?
Yes, let's see. I do want to clarify that I was writing for the court. I always feel funny about saying, I was representing the court, so it wasn't just my own opinion. But I was the drafter of the opinion. And I think that Justice Jackson and I just had different views of the judicial power. Mine narrower, or the court's rather, narrower than the one that Justice Jackson presented. I hasten to add that Justice Jackson and I get along just fine. Justice Scalia used to say, I attack ideas, not people, and that's my motto too. So we were sparring about ideas. It was not personal. But I do believe that. I think the judiciary needs to stay in its lane.
And she wrote a solo.
Correct.
Yeah, and you responded in an interesting way. They got a lot of attention. You clerked for the late Justice Antonin Scalia, who was known also to have a pretty sharp pen at times. When it comes to your point of view and style, how do you see comparing or contrasting to Justice Scalia?
It's hard for anybody to compare their writing style to his, because he was such a fantastic writer. So I'm sure, you know, my writing does not hold a candle to Justice Scalia's writing. In terms of the heat, you know, he was Italian, so I think he had naturally brought a little bit more heat to the pen. So I calibrate mine to the situation, and in that particular opinion, I was writing, you know, in a little bit more of a forceful or, shall we say, spicy way than maybe I sometimes do.
But as far as your point of view about the Constitution, a constitutionalist, the text, explain that for folks. So, in that way, you're close to Justice.
Oh, yeah, of course. In terms of philosophy, you know, I learned from Justice Scalia. And in terms of philosophy, my philosophy tracks his. And that is that the Constitution's text controls, and the way to understand what the text means is to ask how it was understood by those who ratified it when it became law.
And for the folks who say, well, the founders were dealing with completely different problems back then. They were not contemplating what a country could look like decades later. How do you know, they want a living, breathing Constitution that changes. How do you respond to that?
You know, the genius of our Constitution, and I talk about this in the book when I describe originalism and describe our written Constitution, is that it's written at varying levels of generality. So sometimes it's very specific. The president has to be at least 35 years old. But sometimes it's very general. We're protected from unreasonable searches and seizures. We have freedom of speech. And to have freedom of speech doesn't mean that you have freedom only to pass out pamphlets in a town square. I mean, it means that you have freedom to be on broadcast news.
Right, and the 22nd Amendment says you can only run for office for 2 terms.
True.
You think that that's cut and dry?
Well, that's what the amendment says, right? After FDR had 4 terms, that's what that amendment says.
Not asking how you think about an issue, but scheduling the tariff question. We think that would be in coming weeks?
I don't think that has been scheduled yet. But we certainly take into account requests to move things along quickly when it's necessary, but that one has not been scheduled yet. To my knowledge, you might have more current information than I do.
Well, I don't know about that. You live inside these walls here. You spend some time in the book discussing the Dobbs decision, and that overturned Roe v. Wade and the precedent, ending the nationwide constitutional right to abortion, as it's so called. You write the court's role is to respect the choices that the people have agreed upon, not to tell them what they should agree to. Yes. So the court's role, and essentially what the court said in Dobbs, was not that we were taking away a right, but that, as properly interpreted, the Constitution did not protect that right. That it's one left, like virtually every question, to the democratic process. And that's because the court, in interpreting the Constitution is our fundamental document. It's the super law. It trumps every other law. And it represents our fundamental commitments as a people that we have agreed to. And that's a product of the democratic process. That's not a product of what the court imposes on the democratic process. Do you think that decision is misunderstood broadly? I do. Dobbs did not say that abortion is illegal. Dobbs didn't weigh in on that question. Dobbs said it belongs to the political process. And, it's been thrown to the political process, and the states have been working it out. I mean, in fact, you write, getting ahead of the American people came at a cost. Yes. Justice Ruth Bader Ginsburg, who was herself a supporter of abortion rights, pointed that out. I mean, when the court decided Roe, the country was already moving in a direction of liberalization of abortion laws. But the court then was in the business of making a lot of pretty fine-grained decisions about abortion regulations that Dobbs held belonged to the political process. Do you see the passion and how did that affect you, all of the fallout from that case in particular? I think the fallout from that case drove home a point that I make in, I think it's chapter 2 of the book, about the costs of the commission and the oath. You make decisions that are unpopular and you have to face what comes, right? So we don't expect that we will be popular, and sometimes that can be difficult to be subject of public criticism, but that's the cost of the commission. In your nomination hearing in the Senate, Senator Dianne Feinstein said this.
When you read your speeches, the conclusion one draws is that the dogma lives loudly within you. And that's of concern when you come to big issues that large numbers of people have fought for years in this country.
That's about your faith. You write about your faith in this book. You say some suggest that people of faith have a particularly difficult time following the law rather than their moral views. I faced that criticism as a Catholic, most sharply when the Senate Judiciary Committee conducted a hearing to consider my nomination to the 7th Circuit. I'm not sure why. Are you still not sure why?
When I say I'm not sure why, it means what I meant to convey is that people who have faith and people who have no faith at all each have deeply held moral commitments. I mean, I'm fortunate to know many people who do not have faith, who have deep, deep commitments to values. And so I say in the book, whether you are pro-choice because you think you're a secular humanist, but you think it is a fundamental moral right of a woman to terminate a pregnancy, or whether you're a person of faith who is pro-choice because you believe the same, or you are a person of faith who is pro-life, everyone, every single judge, every single person has moral commitments. And I just don't think it matters from where those commitments come. They all must be put aside if one is to judge.
Your book has great pictures from all different times in your life, and also a picture that says 1,000 words as you write, a snapshot of 2 justices riding an elephant together in India, captures the relationship between Justice Scalia and Ruth Bader Ginsburg really well. Are those relationships in this court?
Yes, I think that those relationships, I think what their relationship showed and what people talked about so much after Justice Ginsburg died most recently, is that they could vehemently disagree about ideas, but be close personally, have warm relations personally. And we work on that in the court, to maintain collegiality and friendship and warmth, despite the fact that we have deep disagreements, deep jurisprudential ones.
Are you concerned about security and where the country is going, specifically vis-a-vis the passion that you saw, the attempt we saw on Justice Kavanaugh, the security that you have to deal with day to day? Obviously, you have a large family, 7 children. It's a thing that a lot of public people have to think about. How do you think about it?
Violence and the threat of violence should not be the cost of public service. And so I know that the whole judiciary is alert to this. The Chief Justice has spoken about it. And yes, I'm very grateful for the security that we have, and it is something I'm worried about.
Public perception of the court, how important is that inside the court to all of you?
One reason I wrote the book is I want people to be confident in the integrity of the court, and I want them to understand our decision-making process. The court, however, can't take into account public opinion in making individual decisions, because the whole point of the court, and the point I try to convey in the book, is that you have to follow the law where it leads, even if it leads in a place where the majority of people don't want you to go. And that's because the Constitution trumps regular statutes, regular executive orders, all those things that might be very popular in the current moment. The court has to stand up for the law.
So what about that? Do you like doing this?
Oh gosh, like every job, there are things that I like and things that I don't like. But the way that I try to think about the job is primarily public service. I am privileged to serve, and when people ask if I like it, typically what I say is, it is an honor to serve the United States.
What's the biggest thing that surprised you now that you're into this time here?
I think the biggest thing that surprised me was really the personal change of being a public figure. You asked about security before. Having security in tow was not something that I experienced when I was a law professor or a judge on the 7th Circuit. That shift has been a pretty big adjustment.
Well, the book is Listening to the Law, and thank you. We enjoyed listening to you.
Thank you, Brett.
The time. Thanks a lot.
Thank you.
Supreme Court Associate Justice Amy Coney Barrett highlighted the disconnect between how the public perceives the court and how it actually operates in a wide-ranging interview with Special Report on Monday. We don't wear red and blue, Barrett told Fox News anchor Brett Baer. We all wear black because judges are nonpartisan. Barrett, who was appointed by President Donald Trump in 2020 and has served for nearly 5 years on the nation's highest court, explained why she decided to write her upcoming book, Listening to the Law, Reflections on the Court and Constitution. People across all groups have asked Barrett the same questions, she said. How did this court get its cases? How does the court decide cases? Do the justices get along? And I can't answer all of those questions one-on-one, Barrett continued, but I can write a book so people can find the answers if they're interested. While the Trump appointee aims to answer common questions she hears, she maintained what is popular with the public does not influence her judicial opinions. The point I try to convey in the book is that you have to follow the law where it leads, even if it leads in a place where the majority of people don't want you to go, Barrett said. The Constitution trumps all written laws, Barrett argued. Barrett echoed her originalist philosophy as she went on to address criticism of the controversial Dobbs ruling that overturned the constitutional right to an abortion. The Dobbs decision is misunderstood, she argued. Dobbs did not say that abortion is illegal, Barrett stated. Dobbs didn't weigh in on that question. Dobbs said it belongs to the political process, and it's been thrown to the political process, and the states have been working it out. When asked about her Catholic faith, something that has drawn criticism since her nomination hearing in the Senate, Barrett broadened the conversation to include all deeply held moral commitments a judge can hold. Whether you are pro-choice because you think you're a secular humanist, but you think it is a fundamental moral right of a woman to terminate a pregnancy, or whether you're a person of faith who is pro-choice because you believe the same, or you are a person of faith who is pro-life, Barrett began. Everyone, every single judge, every single person has more commitments. And I just don't think it matters from where those commitments come. They all must be put aside if one is to judge. Barrett's book, which explores the court's processes and relationships between judges in greater detail, is set to release Tuesday, September 9th.